Happy holidays, everyone. I hope that you are enjoying the pre-season for all of the festivities that this season has. I am joined today by Jarrod. By the way, I'm Diane Cohen of MacroPro and Jarrod Zea. Jarrod, can you tell us what you do and who you're with?
Yes, thank you, Diane. Hello, everyone. So like you said, my name's Jarrod Zea. I'm a certified structured settlement consultant, a licensed fiduciary in California, and a national certified guardian. I've been with Ringler for about 16 years. What we do is we're here to be a resource for you and your team in anything related to the settlement process, whether that be structured settlements, trust solutions, or the coordination of public benefits. We're here to help bring solutions that, to the table that really help the injured party plan for life after settlement. And we're also here to assist claim handlers in evaluating and determining case value when the parties are ready to negotiate. So I'm really happy to be here.
I think you guys are really way underutilized in our industry. I think what you guys do really helps stretch the dollars and gives the injured worker much more relief, and believing that what their payout is going to last them for years to come. So I think that your product is great. So Jarrod, are you guys, I've got a question for you, but I'm going to ask the same question to the audience at the same time. So those of you attending, please answer this question in the question box. So Jarrod, are you hosting or are you a guest this holiday season?
So this holiday season, I am mostly going to be a guest. I'm going over to my parents' house on Christmas Eve, and then my mother-in-law's on Christmas Day. We're going to do a little Christmas morning here at home, but I'm going to say I'm a guest.
Well, Jennifer and Jessica and Emily are saying one is hosting, one's a guest. Another person is saying that they're taking the kids over to the grandparents. Emily, Christine says she's a guest, and Emily says she's a guest. So that's wonderful when you can be the guest. Someone says that they are a guest, but they're going to help their mother clean the house. Now that is a good child. That is fantastic. All right. Well, Jarrod, I got a little bit of housekeeping, and once we do that, I'll turn that right over to you, everyone. Just a reminder that today's webinar is with One California CEU. You must be logged onto the Go Webinar platform so that your certificate comes in your name, so you can't be using somebody else's link. If you're calling in by phone, I'm sorry, they are unable to record your time and attendance. Jarrod does have a handout, so if you'd like to download that now, please do so that you have it for your records. There is lots of great information on that. Also, if you'd like to ask a question of him, please put it inside of the question box, the same one that you gave us your answers to, and he would be happy to answer you. And then lastly, if you'd like to see this or any other program that we've had, you do so by going to the MacroPro YouTube station. All right, we are going to hand this over to Jarrod.
Thank you. First off, thank you everyone for taking the time to attend this webinar today. Like Diane said, feel free to add questions to the chat as we move through the presentation. I will also leave some time at the end for questions. So let's jump right into it. So just a quick overview of the agenda. We're just going to talk about what a structured settlement is, why they're utilized, who a good candidate is, and when you should consider a structure, when it should be used, special considerations regarding public benefits, and then lastly, how you go about facilitating getting a structure. So what is a structured settlement? Simply put, a structured settlement is any settlement that is not paid as a lump sum cash payout. IRS code 104A2 of the Internal Revenue Code states that any funds received as part of a settlement that involves physical injury is tax-free. That includes payments from structured settlements. Structured settlements were formalized into law via the Periodic Payment Settlement Act of 1982. This act was passed by Congress to encourage the use of structured settlements as a way to provide long-term financial security to individuals receiving damages from personal injuries or from physical sickness. So why use a structured settlement? If we're talking about benefits for the insurer or the defendant, so what are the benefits? One of the major points I want everyone to take away from today's presentation is that first and foremost, structured settlements are a negotiation tool. You know, when we get to sit down and have a conversation with the claimant about what their concerns are regarding their future needs, it really gives us the opportunity to show how we can guarantee that the funds for those needs will be available in the future when they need them. You know, a structured settlement really can bridge the gap between the settlement authority you have to work with and the demand made by the applicant's counsel. Let's say there's a demand of 250,000 and our authority is only for 175. The yield produced by the periodic payments over the lifetime of the annuity can really bridge the gap. I'll show you an example of this shortly in the presentation. Structured settlements help facilitate a more needs-based approach to settlement. We can put together a plan that addresses specific needs and show the cost to cover those needs over their lifetime. A lot of times, claimants will have this pie in the sky number that either a colleague shared with them or their attorney shared with them at the beginning and the onset of their case, and they fixate on that. And it can really stall negotiations. When I get to sit down and break down every single specific need that they're concerned about, break down the cost, show them how we're going to fund it, it kind of puts the ball in their court for, okay, they've basically addressed all my concerns. What's the real sticking point here? And it really helps negotiations move forward. Using medical records, we can request rated ages from underwriters of the life markets we quote to ensure you receive the best pricing possible for the needs that we're considering. If you have a claimant with considerable comorbidities or health issues, even if it's not industrial related, a rated age can make a significant impact during negotiations. Pardon me. Structured settlements can also reduce legal fees and allocated expenses by facilitating quicker settlements. Usually, you know, we're more aligned with the claims handler in getting a case resolved in a timely manner. So here's some more bullet points for benefits for the insured and the defendant. When we assist on these cases, we're really dealing with unique investors. Most of the claimants I speak to have been living paycheck to paycheck or have been doing that for a portion of their life. They're going to receive a settlement that's purpose is to treat their industrial related injury for the remainder of their life expectancy. You know, structured settlement payments are guaranteed and they're not affected by market fluctuation. So it really provides that sense of security going into the future. There's a story that comes to mind often when I'm giving these presentations of an individual we dealt with who was receiving a sizable settlement in the range of 600,000. He told us his brother was a day trader and he wanted to give the entire settlement to his brother to invest in the stock market. We convinced him to take half of that and put it into a structure to be paid to him monthly. He can, when he receives the funds monthly, he could direct it directly to his brother. We call it dollar cost average investing. He called us. We settled his case, I believe, at the beginning of 2008, maybe end of 2007. He called us in 2009, thanking us. He said his brother had lost a lot. He hadn't lost as much as his brother, but he still had this monthly income coming in that he could rely on. That's kind of the poster child story for why we do what we do and how we do and how it creates a socially responsible settlement. We use a qualified assignment to assign the responsibility to make future payments to the life company. So the carrier or self-insured is not responsible for any missed payments should the claimant move or a check gets lost in the mail. A qualified assignment is a legal process that allows the defendant or their insurer to transfer the obligation of making structured settlement payments to a third party, typically a qualified assignment company. This process is governed by Section 130 of the Internal Revenue Code. It ensures the transfer is tax neutral for the defendant while preserving the claimant's tax-free status under Section 104A2 for payments related to physical injuries or sickness. So that qualified assignment is really crucial in terms of transferring that obligation so that you know there's no liability going forward. Structured settlements protect insurers and employers from CMS-related issues and effectively safeguard Medicare's interest by enabling compliance with Medicare set-aside requirements. Instead of funding the MSA as a large upfront cash payment, by using a structure periodic payments can really reduce the immediate financial burden while ensuring future medical costs are covered. This approach really aligns with CMS guidelines, preventing Medicare from paying for expenses that the settlement should address, therefore avoiding potential penalties or reimbursement claims. Additionally, structured settlements lower the overall settlement costs through the cost efficiency of annuities while providing predictable long-term funding for the claimant's needs. And finally, utilizing structured settlements in the negotiation process, it really shows you are pursuing settlement in the utmost good faith. This avoids liability for failure to pursue a reasonable settlement. I'll mention this a couple of times. If you only offer cash as a part of a settlement, the only way you have to move is by offering more cash. By utilizing a structure, you're able to make that one cost level look several different ways. And so it gives you more options. Skip the slide there. So for the adjuster and the examiner, a structured settlement consultant, we really will never negotiate on your behalf or convey information that we're not authorized to do so. But we will encourage communication in order to determine what the barriers are that are preventing settlement. We do this so we can go out, find the solutions that are needed to get the case done. Also, by utilizing a structured settlement, we're able to put together hypothetical scenarios in which the parties can review and consider. This really helps streamline the process. It doesn't have to be, every quote we provide this is a straight offer. They can be hypotheticals. They can be, if we were to offer something like this, would you accept it? That can really help move the process along. Structured settlement consultants do not bill by the hour. We are compensated via a commission paid by the life company we place the annuity with. Therefore, it is no cost to claims to reach out to their structured settlement representative to obtain present cost proposals for case analysis or proposals that can be offered for settlement consideration. I like to say sometimes we're one of the best values in claims because we're here to be a resource for you and your team. If we don't have an answer for you right away, we know somebody that does, and we'll get it to you very, very quickly. So please feel free to use your structure representatives as a resource for information and just to bounce ideas off of. So next, let's look into how we identify good candidates for a structured settlement. First off, minors and incompetent claimants. Most judges in California prefer a structured settlement over a blocked account. 9 times out of 10, we can do better than a blocked account in terms of rate of return. If somebody's over 16 and they're going to receive their funds at 18, that's when it starts to get into the range of we can't produce too much of a return. But any age under that, we always will do better, even if it is a lump sum paid out at 18. Next, it will be Medicare beneficiaries or Medicare set-asides. On average, if you're seeing a Medicare set-aside on a case, you should think structure because we can typically save 15 to 30% off the total allocation amount of the MSA than if you were to pay it by cash. So if you're paying a MSA as a lump sum, you are overpaying it. If you ever see an MSA with a value over $25,000, always think structure. And as a side note to that, when you get the structure quote for the cost to fund the MSA via structure, ensure that your defense counsel begins negotiations using the cost to fund the MSA via structure and not a lump sum. I say this because a lot of times there will be settlement negotiations ongoing and everybody's discussing the MSA being paid as a lump sum. And at the end, if you try to bring in the structure, the applicant attorney will go, we don't want that, we just want the lump sum. It's much easier to start negotiations with the onset of we're structuring the MSA and retaining the savings via the structure. Next are claimants unwilling or unable to manage their finances. I have an interesting story for this one. I had a relative who was minor when they were involved in a dog bite and they received a settlement from that dog bite case. It was in the range of 60,000. I did my best to convince him to structure it so that he could learn how to spendthrift and use the money wisely. He decided to take all the funds at 18. He moved out, bought a big truck, got an apartment, had his friends live with him for free. After 18 months, the money was gone. He was back at home. He had to sell his truck. And it just another story of why we do what we do is to make sure that we provide that financial security and that we help these individuals maintain financial stability into the future. Next, it's cases involving future wage loss. Structured settlements are an excellent solution for this because they provide a reliable stream of income to replace those lost earnings over time. These payments can be designed to mimic the claimant's previous payment schedule, offering financial stability and ensuring that their living expenses are consistently met. Cases involving future medical needs and costs. This is a really important point. If a claimant has recurring medical costs such as prescriptions, medical services, durable medical equipment, structured settlements can provide a cost-effective solution by projecting and pricing these expenses over their life expectancy. This approach ensures that the claimant receives adequate financial resources to cover their medical needs without exhausting their settlement prematurely. For catastrophic cases involving comprehensive medical care, it's even more valuable. Structured settlements guarantee the funds will be available when needed. It offers them that peace of mind, and it also offers the family peace of mind that the money is going to be there when they need it. So some attorneys are able to structure their fees, but it's not on a tax-free basis. Wrongful death, surviving family. This is another great point. Structured settlements can be beneficial for surviving family members in wrongful death cases, providing that stability and security during really emotionally unstable times and challenging times. These settlements can be tailored to deliver periodic payments that help reduce the income, replace the income of the deceased, ensuring that the family has a steady source of financial support for essential expenses such as housing, education, daily living. This approach minimizes the risk of mismanaging a lump sum and ensures the funds are available for the family's long-term care needs. Additionally, structured settlements can provide payments customized to meet specific milestones, such as a child's college tuition, significant family events, for surviving spouses and dependents. The predictable and tax-free nature of structured settlements payments, they really offer peace of mind, and that they know that I'll have that income coming in so that I can continue to care for my loved ones. Catastrophic injuries, we already touched on that. As I mentioned, they're great for these cases because usually you have ongoing medical needs like a van replacement fund. They need a new wheelchair every a certain amount of years. We're here to price out those needs, so at the time of settlement, you can fund those needs at a lower cost and get the case done. Potential Medicare and Medicaid recipients. I'll touch on this a little bit more later in the presentation. So there is a misconception that structured settlements are only for catastrophic cases, and that is not the case. As you can see by this chart, over 60% of cases we structure have a case size between 0 and 100,000. Many claimed handlers will ask me when they should consider a structure on a case, and my rule of thumb is if you see an MSA $25,000 or above, or if the case is going to potentially settle over $50,000, you should consider a structure and get pricing. I will mention the minimum premium amount for a structured settlement is $10,000. So if the premium comes in under $10,000, we cannot structure the case. What does my consultant do? Well, first and foremost, while opportunities for in-person meetings with claimants are certainly less frequent than they were before the pandemic, these interactions can significantly increase the likelihood of reaching a settlement. Engaging directly with the claimant, whether face-to-face or via Zoom or conference, allows us to foster that open communication I had mentioned before and create a forum where the claimant feels heard. By involving all the parties, we effectively provide the claimant an opportunity to voice their concerns and grievances, often leading to a mutually acceptable settlement. It in a way, we're giving them their day in court when we have an opportunity to sit down with them, their counsel, defense counsel, and let them air out their grievances and let them air out what they're concerned about. And it really leads to better outcomes overall. Engage directly with plaintiffs to identify needs design. Yeah. There was a situation where I was across the table from an old elderly woman whose case was open for a very long time. She was very frustrated with the process and the insurance carrier. We were doing our best that day with all the parties there to negotiate a settlement. We had put together some proposals. We hand the proposals over to her across the table, and she was so frustrated with everybody that she crumpled it up and threw it right back at us, literally physically threw it at us. I sat down with her and I just basically said, I'm here to listen to what your concerns are and to do my best to bring the solutions needed to get this done today. What can we do? She started telling me about her life story, how much she loves her grandkids, not her kids so much, but that she really loves her grandkids. And I ended up putting a proposal together that took $20,000 of her settlement offer and had it being paid out when the kids reached age 18 as an education fund. This would give her the ability to leave some kind of legacy for the grandkids she loves so much. And because I did that, it really changed her demeanor in the negotiation, and we got the case settled that day. So that's just an example of, if you give us the opportunity to engage with the parties and facilitate that open communication and dialogue, it really increases the chances that you're going to get that case settled, and it's going to be a reasonable amount. We're here to educate the parties on the benefits and the process of structuring. Our job is to provide you with the benefits of structured settlements as a negotiation tool. That includes, ensuring that utilizing a structure is not a barrier or obstacle to settlement. We are here to make the process of structuring easy and seamless. We're not here to get in the way. So that's our job, is that if you will consider a structure on a case, we're going to make the process streamlined and we're not going to be a barrier. Structures, it secures relative. We're able to ensure that when we provide pricing on particular benefits, the rates that are being used are the best available on the market. We do this by obtaining rated ages. I'm going to go into a little bit more detail on rated ages a little bit later, so I don't want to dive too deeply into that. We can prepare what if proposals as a negotiation tool. Again, those what if scenarios. We can also provide present cost and present value proposals, and we can also provide what if settlement proposals that give claims and defense counsel real world concrete numbers they can use during negotiations. Many times I'll be asked for present value. Present value I can certainly do, and it's usually based on the assumed interest rate that you give me. But when I provide present cost proposals, those are based off of real world numbers the life insurance markets we quote are providing us. So they're a lot more concrete when you're discussing settlement and when you're negotiating. Trust expertise to protect public benefits. We understand that some applicants who are considering settlement may be receiving public benefits like supplemental security income or Medicaid. We can provide trust products and solutions that enable applicants on public benefits to settle their case while maintaining eligibility. Lastly, we can assist your counsel in drafting the CNR documents or settlement agreement and release documents to ensure that all required structure language is incorporated in the documents properly. Pardon me 1 second. Are there any questions? Okay, nothing yet. Okay, so.
Nothing yet.
Okay, great, thank you. Special considerations. For those claimants who are Medicare eligible or will be in the next 24 months, you are required to take Medicare's interest into consideration when settling a workers' compensation claim via a Medicare set aside. Again, we can on average save you 15 to 30% off the total allocation of a Medicare set aside. If you see a Medicare set aside, you should always think structure. Upon receiving a Medicare set aside on a file, it is important to first consult your structured settlement expert to obtain that annuity pricing for the funding of an MSA through structure. This allows you to incorporate the structure funding cost into the settlement negotiation, like I mentioned earlier. You want your counsel to start negotiations based on the cost to fund the MSA via structure and not as a lump sum. It ensures that either the carrier or self-insured are going to have a much higher chance at retaining the savings by structuring the MSA. Here are some of the factors that determine the amount and the pricing of the MSA. When the MSA is being drafted, typically the MSA vendor looks back at least 2 or 3 years of treatment to determine ongoing medical care. They can include an annuity breakdown, which provides seed funding that is equivalent to 2 years of treatment, followed by annual payments that reflect the annual cost of care. Here's an example of how structured settlements can provide significant savings when utilizing them for Medicare set-asides. We took 5 random cases from a California self-insured entity we've done work with in the past, in which we structured the MSAs upon settlement. By structuring the MSAs on these cases, this self-insured saved $41,611, and that's only on 5 random workers' compensation settlements. When you see an MSA, remember, think structure. When considering settlement on a claim, it is important to consider the claimant's overall life expectancy to help determine medical cost. You will want to determine if the claimant's comorbidities and/or injuries would warrant a reduction in life expectancy. These comorbidities do not have to be industrial related. For example, it can be a history of cancer in the family, diabetes, drug or alcohol addiction. We are looking for anything in the medical records that the underwriters would consider relevant when determining life expectancy. We'll take the medical records you provide us and submit them to the life companies we utilize. Each life company will issue their own rated age. Please be advised that there's a difference between the rated age you will sometimes see on a Medicare set-aside and the rated ages we provide. The difference is when the rated ages we receive take investment risk into consideration. So they sometimes can come in a bit different than what you will see on an MSA. Here again, you can see some of the conditions you'll want to look out for when considering settlement on a case. Typically, we only need 1 or 2 medical reports. We only need 2 or 3 medical reports typically from the last 2 or 3 years to request rated ages. Life companies will only accept about 15 to 20 pages. So the medical reports you do provide us, we want to make sure show the most relevant and aggressive comorbidities so that we can get you the best pricing when pricing out ongoing needs. Here's an example of how obtaining a rated age can provide significant savings when pricing out ongoing care needs. Here we have somebody who is chronologically 40 years old. To purchase a benefit of $1,000 a month for life with a 20-year guarantee, the cost would be around $280,000. If we were to submit medicals and obtain a rated age of 55, we can purchase the same $1,000 a month for $40,000 less. So you can see that these kind of savings can really be significant, and they can be used to address either other concerns on the case or just to have those savings retained by the carrier or self-insured. Here's an example of how structured settlements can be used to really bridge the gap during settlement negotiations. The proposal includes cash up front to the applicant, attorney fees of 15%, the MSA seed fund, MSA annual payments, and a lifetime monthly income. If you move your attention to the cost column, you'll see that the total cost to fund this proposal is $250,000. Say you have a max authority of $250,000, but the applicant attorney has made a demand of $400,000. With this proposal, you're able to take that $250,000 we have in authority and have it yield almost $377,000 over the life of the annuity payments. This provides an option within your authority that helps bridge that gap between what you have to offer and the applicant's demand. So that's a really important point is, as you can see here, we really break down every facet of the settlement so that they can see where each part of it is going, what it's supposed to be intended for, and And when you provide a proposal like this to the other side, it gives the applicant something to look at and go, can we move maybe some of the monthly into the cash up front, or some of the cash into the monthly? I want more of an income going forward. It provides a steady platform for everybody to start having productive conversations regarding how we're going to get a case settled. So I'm going to move into the coordination of public benefits. As settlement consultants, we often run into individuals that are on crucial public benefits, whether it be SSI or Medicaid, and we have to make sure that we structure the settlement in a way where they don't lose eligibility. So first, let's review the 3 different types of Social Security programs that may affect settlement planning. First, we have supplemental security income. This is a needs-based program designed to meet the basic needs of citizens who fall under the federal poverty level. Second, we have standard Social Security. It is designed to provide financial support to individuals during retirement, disability, or to survivors of deceased workers. Workers, they typically earn Social Security through credits by paying taxes through employment. Typically, it's 40 credits in order to earn that eligibility, which is an equivalent of about 10 years of work is needed in order to qualify. Finally, we have Social Security Disability Insurance. This is a federal program managed by the Social Security Administration, designed to provide financial assistance to individuals who are unable to work due to severe long-term disability. Medicare versus Medicaid. Now we'll touch on the difference between these two. Medicaid in California is known as Medi-Cal. Medicare is a federal health insurance program in the United States, primarily designed for people ages 65 and older. The majority of Medicare beneficiaries are in this group of 65 or older. Certain younger individuals with disabilities, this includes people who have been receiving Social Security disability insurance for a specific period. Another group who are eligible are those with end-stage renal disease, those with permanent kidney failure requiring dialysis or a transplant. Medicare eligibility is earned by paying taxes, of course, like I said, through employment, typically for a minimum of about 10 years. Part A of Medicare covers basic hospital care. Part B is for physicians and outpatient care. Part C is basically private insurance, is a private insurance hybrid, combining parts A and B with other benefits. And then Part D is private insurance prescription drugs. So it's a private plan. Medicaid is known as Medi-Cal in California, is a joint federal and state program that provides health coverage to low-income individuals and their families. So for individuals involved in settlement planning, understanding the interplay between SSI, supplemental security income, and Medi-Cal is critical. Proper planning can help maintain eligibility for these benefits, ensuring continued access to essential health care and financial support. This is Medicaid is a needs-based program. You do not need to pay into the system for a certain amount of time to be eligible. Eligibility is based on the federal poverty level. Medicare eligibility requirements can vary state to state. Typically, SSI, supplemental security income, and Medicaid eligibility go hand in hand. If you qualify for SSI, you are typically automatically enrolled in Medi-Cal. As of January 1st, 2024, there are no asset limits for eligibility to Medi-Cal. This only applies to the state of California. So if you have an individual that is planning for a settlement but plans to move out of California, you have to take a whole different set of facts into consideration than for an individual that does not plan on moving out of California after settlement. Again, if you're working on a case with an applicant that is eligible or receiving supplemental security income or Medicaid, the settlement will need to be structured in a way that payments do not disqualify the applicant for these benefits. This not only applies to the injured applicant, but if they have dependents in their home that are receiving public benefits, those dependents could also become disqualified if the settlement is, if the parent or guardian or spouse, if they receive the settlement, the dependents in that household can become disqualified. So I worked on a case where the parties were ready to settle, but the claimant's wife was receiving dialysis through Medicaid. If the claimant were to accept that settlement without having it being placed into a trust, his wife would have lost eligibility to Medicaid, which would have jeopardized her ability to access dialysis care. And the reason that's so serious is once benefits have been revoked, it can take up to 16 to 18 months to get a hearing and appeal the decision that revoked that eligibility. So they will have to wait 16 to 18 months and find another way to get care until they can get in front of a judge and let them know that I need eligibility. This was done in error. You know, your settlement consultant can really assist you in providing trust solutions and other options that enable these individuals to settle their cases without losing eligibility. Pardon me. I use a lot of water today. Okay. As a California licensed professional fiduciary and a national certified guardian, I have assisted many individuals in navigating the settlement process and maintaining their eligibility for SSI and Medicaid. I was recently able to assist with a settlement involving an autistic minor that suffered a dog bite injury. The settlement was for about $60,000. The judge overseeing the case was really hesitant to approve it at first, as typically settlement funds being paid to a plaintiff with a disability required probate oversight, and he wanted to push to probate for oversight if it was going into a trust. Thing is, probate oversight requires annual accounting of the funds, which would have cost around $2,000 a year. At the minor's current age, the court accounting would have reduced the settlement funds by about $12,000 by the time the minor reached age 18. So we decided to create a plan where we structured the funds to be paid at 18, but to be paid to a special needs trust. So the plaintiff, when the plaintiff reaches that age of majority, we bypassed all those probate fees and we gave the plaintiff the ability to access SSI and Medicaid in adulthood. You know, this really ensured that all of the funds for that settlement could be utilized to support this minor's educational goals and quality of life. That's just one example of how a settlement consultant can assist you in making sure that we provide the solutions needed to get a case resolved. So to review, first and foremost, structured settlements give you the ability to present multiple settlement offers that can be tailored to address the specific needs of each individual claimant. If you only offer a lump sum cash settlement, during negotiations, the only option you have is to offer more cash. Structures really give you that flexibility to make one number look several different ways. Security. As we touched on multiple times during the presentation, when discussing settlement, we often are dealing with really unique investors who are set to receive a large sum of money that they are to utilize to treat their injuries for the remainder of their life expectancy. Structured settlements are really important in helping provide the financial stability and security these unique investors can really benefit from. And I think that's one of the major points of the presentation, is that we're here to provide a vehicle that gives them peace of mind, lets them sleep a little better at night, that they know they have income coming in, and despite what happens. Customized, tax-free, of course, that's a huge point. We're one of the only products that can do that, if not the only product. Cost savings, utilizing structured settlements during the negotiation process will provide for faster resolutions and overall better settlement outcomes with more cost savings to the carrier and self-insureds. And reduce litigation risk. By presenting a structure offer during negotiations, you really show the utmost good faith that you're trying to resolve the claim. There's also scenarios where if you're dealing with a very large case with large medical exposure, I've ran into situations where the carrier is self-insured or just, they don't want to fund it. It's too much. We're just going to manage the care ongoing. we have different benefit types called cash refund, where we can fund these needs. And once the applicant dies, any remaining premium left in the annuity can come back to the carrier as self-insured. If we can also do reversionary on medical needs. So if you have an MSA, you can professionally administer it, and any money left in that MSA account can revert back to the carrier as self-insured upon the passing of the applicant. If you have significant medical needs and we have particular medical networks that we can go out and provide certain, we call them care quotes, where we can provide better pricing on particular medical prescriptions and services. If we're dealing with a minor that's looking to go to college, we are able to provide a plan that pays them their settlement funds at a part of the year where they're not applying for financial assistance. They spend down the funds within that year, within that time frame, and when they apply for financial assistance, there's nothing in their bank account, so they can receive financial assistance while also receiving the funds from their settlement. And finally, if somebody doesn't want to structure but wants to invest their money, we have strategic partnerships with investment management firms that can really help them do that in a financially wise and stable way. So thank you so much for listening today. I want to open it up for questions should anybody have any, and yeah, please feel free to enter them into the chat.
I don't see any questions right now, but I have to say that we did get a very nice comment about this being great information, and it really is great information. A lot of times we need creative solutions in order to get a claim to close and to get them off of our files, because everybody, I mean, the big push is always to get those claims closed, especially this time of year. It's an amazing time to make that offer. I have to say it was very creative of you to work a way for that grandmother to leave her grandchildren something.
Yes, yeah, and there's a lot of scenarios where it's a very angry individual, and you give them that day in court, you give them that day, quote unquote, in court, but you give them the opportunity to grieve to address their grievances and kind of convey what they're concerned about going into the future, and it really helps facilitate planning.
Well, Jarrod, I want to thank you very much for joining us today with this very informative webinar with all of the tips. I think people sometimes forget to remember that they can use structured settlements. Well, on behalf of
MacroPro, so much, and I really appreciate the opportunity. Everybody feel free to reach out should you have any questions or anything like that.
On behalf of MacroPro, we'd like to thank all of you for attending today. We have no more webinars for the rest of this week. However, we will start again on Monday with two more webinars. We will have a total of 13 webinars. So we kind of got a baker's dozen for you. That way, if you miss one of the 12, it's no big deal if you're trying to get all of them. Hey, real quick to our audience, can you put in the question box how many times you have attended the 12 CEUs of Christmas so far? It'll be interesting to see because you are number 5. So I wonder if anybody has been to all 5 yet. Somebody says 2. Someone's, oh, there are a lot of thank yous here, Jarrod, for your presentation. It was all but one. Quite a few people that say 3. Yvonne says she's been here 5. Karen's 2nd. This is her 2nd. Lynette is 4. Stacy's 5. Great presentation, it says here. We also have 4 or 5 that lost track. Let's see, we got another one for 2. This is their first. Well, we certainly hope that, Tamara, you will come back for the others. All right, well, until Monday, I wish you all a great and fabulous week and hope that your holiday shopping is not too taxing. Bye-bye now.
Bye-bye.